Our other big story at 6 o'clock, a tense exchange between a judge and a lawyer. An exchange that landed the lawyer in jail and many questioning the judge's tactics.
Well, I want to try to keep him clean.
So
when you tell him, would you please be quiet? I really appreciate that. Thank you.
I apologize.
Tonight we're unveiling the audio recordings inside a court battle that is getting a lot of attention now, and the judge may be in the hot seat.
24-hour News 8's Leon Hendricks is on this case. He's taking a look at the recordings and what could happen if the judge is found to be in the wrong, Leon.
Well, Brian and Sue, we went to the chief judge of the court where this happened so we could show you what was said and how it was said. The chief judge admitted that what happened on the tape may be embarrassing for his colleague and friend, Judge Kenneth Post, but he released it in the interest of allowing the public to know what happened in an open court. Now the question is, what happens if the judge is indeed found in the wrong? And we found that it's a rare case for discipline to come down against someone on the bench. It's what you might have called a routine appearance that Scott Millard was making. It was his client's first on the charge, a hearing called in arraignment. Things seemed normal until the judge asked this question, and the attorney was ready to put up a fight against his client giving an answer.
When they give you a drug test today, you're going to be clean or dirty?
Mr. is going to stand mute to that question, Your Honor.
He's not going to stand mute. He's either going to answer the question or I'm going to remand him to jail.
It was tense interaction from there on out as Ottawa County District Court Judge Kenneth Post continued to ask the same question.
When was the last time that you used controlled substances? Let me have a date, please, sir.
Your Honor, Mr. has a Fifth Amendment.
I'm not charging him with use of controlled substance, counsel. He's not charged with that charge. I'm interested in getting a clean, honest bond response. Now, if you don't want to do that, you can leave. Your call.
Mr. has a Sixth Amendment right to effective assistance of counsel.
That's right, and that's not what he's getting at the moment.
Your Honor, I strongly disagree with that.
I'm glad.
I've been nothing but respectful, and I will always be respectful to the bench.
Then would you please let him answer my question?
But Your Honor.
But Millard, the newly licensed attorney for the Mile and Carr law firm, remained firm, even as the judge started to make threats.
Excuse me, Mr. When was the last time, the date that you last used controlled substances?
Your Honor.
One more word, and I'm going to hold you in contempt.
The judge gave his reasoning for wanting the answer to the question.
This is a legitimate question, and I'm going to ask it in determining what the bond level is going to be. And he's going to answer it, or you're going to go to jail, and then I'll start dealing with him. The choice is completely yours. I don't want to go down this road. Don't force me to go down there, sir.
Cooley law professor Kurt Benson.
It's pretty elementary, and I think every elementary school kid knows that the Fifth Amendment says you do not have to incriminate yourself. I'm sorry, but throwing somebody in jail for doing their job and doing it correctly strikes me as wrong.
Your Honor, he was not on bond.
I don't give a rat's tail.
He didn't have a condition of bond.
Millard didn't budge, and in the end,
Counsel, I'm holding you in contempt of court. Remand him to the jail.
we should point out those are edited excerpts of that proceeding. While the vast majority of attorneys and former judges we spoke with would not go on the record, many of them said that what Judge Kenneth Post did was concerning, but it will be up to the Judicial Tenure Commission to deal with that. Once they get the complaint, they could decide anything from nothing to a sort of reprimand all the way up to suspension or removal from the bench. Any type of punishment is a rare occurrence, only has been recommended 87 times in the state of Michigan since 1969 when the Judicial Tenure Commission came to be, in spite of an average of 600 complaints against judges statewide each year. Judge Post drove away when we tried to approach him and ask him about this on Monday. We'll let you know what happens as the attorney involved works to fight his contempt conviction and seeks action against Judge Kenneth Post. Sue.